Received a call today from a family who wanted to hire me as their lawyer and fire their current attorney. And being fired as an attorney happens to all lawyers. I don't think I've ever met any a lawyer in my entire career who's never been fired at least once. So in most situations, it's nothing against the attorney's abilities. It's simply an issue where the client, the family, and the attorney are having a communication issue. And obviously, in a criminal representation matter, the communication between a client and the attorney is critical. So in this situation, prior to taking on the representation, I asked the family a series of questions that I always ask whenever I enter my appearance in place of another lawyer. Why do you want to fire your current lawyer? Because there are many cases that I won't take because I think it's a situation where I'm going to have perhaps the same problem as this current attorney. So that's important to understand. You never want to fire a lawyer simply based on what other non-lawyers are telling you. For instance, in this particular situation, the family had told me that the attorney wasn't doing enough to have their loved one released from jail, and that while they had filed a bail motion, the bail was reduced, but it didn't come down far enough, and the attorney simply didn't make the proper arguments in their opinion. Now, look, I've written articles, I've done videos, I've done podcasts on bail motions. So obviously, I am very familiar with what needs to be argued and what's not appropriate during a bail motion. Bail motions aren't trial; they're not pre-trial motions in the sense of like a motion to suppress, which I've also written articles on. But bail motions, again, danger to the community, propensity toward violence, flight risk, contacts to the community, out-of-state contacts, those are all valid bail arguments. Arguments about defense, self-defense, that the drugs or guns are not admissible at trial, those aren't bail arguments. And using examples from other people's cases, people who the court isn't familiar with, who there's no and where there's no precedent or something the attorney can actually direct the judge to, isn't an appropriate argument. So in this situation, I had asked this family, I said, well, why do you believe this lawyer didn't do enough? And they said, well, our friend had a case very similar, and he was able to get his brother was out on a bracelet for attempted murder or some really serious charge. And it's always a situation where there's an extreme example. And whenever a person gives me an extreme example, I'm always kind of hesitant to continue the representation because, again, you want to hire and fire a lawyer based on a valid reason. And really, you don't want to go off of, well, my friend told me this, my friend told me that, or my cellmate told me this. Again, those aren't valid reasons to discharge or even hire a lawyer. Every case is different. You want to ask an attorney questions based on just valid concerns that you have. What do you plan on doing to help me? What in cases like this, what have you done? What is this judge like? What can we expect in terms of arguments before trial, during trial? What is the probability of success at trial? Again, these are all valid questions that you should have. Obviously, communication, the attorney's not returning your calls or emails or text messages, that's an issue. But again, if you're constantly bombarding the attorney with questions and they're giving you answers, but you're not satisfied with the answer because you're being told something from someone else who's not a lawyer, that's not really fair. Because again, you're asking an attorney to defend a position that simply isn't really a valid position from their standpoint. You're giving an example that's way out in left field. That's something that the attorney has probably told you, look, that's probably not going to happen. That's really very unlikely to happen. So again, you have to consider, again, the question that you're asking the attorney. And if you're asking the attorney a question, he's giving you an answer. Again, think about the answer first. Don't go off of just what you're being told by some third party who you really don't know much about that case at all. So if you have questions about your legal representation and you are considering changing an attorney, again, it's a difficult situation. Please, speak to the lawyer first before you think about discharging the person. Give him or her that ability to at least explain why he or she is pursuing this current course in a case. If you have questions, I'm more than happy to answer them at 215-755-9000. On my website, gambonelaw.com, we have a variety of resources, free books, videos, blog, a podcast. Again, all these resources are meant to make you an educated client. We want an educated client. We believe that an educated client is really in the best position to get a great result in the case. We want you to be active participants in your criminal defense. Again, I'm more than happy to answer your questions, and I hope you are staying safe during this shutdown. Hopefully, I'm hearing that we're coming to an end. I've heard some good things about, I think, the shore this weekend, possibly, if I heard it correctly, parts are opening up. I heard Delaware may be opening up as well. Hopefully Pennsylvania, even though, my home is no longer in Pennsylvania, hopefully that's opening up for my family who is there. Again, so all good things. I think we are coming to an end. Hope you're all doing well, and I'll talk to you soon. Have a great evening.